Welcome, and thanks so much for joining our AI Masterclass today, Contractual Risk Shifting in AI, Mitigating Liability in a Rapidly Evolving Landscape. We're pleased to have a special guest speaker today, Neil Peretz from Enumero Law, so looking forward to hearing his thoughts. Quick reminder, these AI Masterclasses are brought to you by Marashlian and Donahue, the ComLaw Group. We are a dedicated group of attorneys and technical experts who help clients navigate today's complex legal landscapes. Our team has deep expertise in AI technology, AI governance, the laws covering AI, privacy, consumer protection, and of course, telecommunications. We collaborate with clients developing and using AI to effectively leverage the technology while mitigating legal and ethical risks. We also want to recognize today the CCA, the Cloud Communications Alliance, which has been a strong supporter since the beginning of the AI Masterclass series. Thanks so much to the CCA. Vision AI Plus Group is our team of legal and technical experts that help guide companies in the development and use of AI. And I am Brian Alexander of counsel at Marashlian and Donahue. I specialize in AI, privacy, and cyber law, and I work with companies on AI governance, contracts, technology transactions, as well as IP and corporate matters. Currently, much of my time is on helping companies implement AI risk management, compliance programs to ensure they're compliant now and that they're prepared for future regulatory change. We all have a good understanding now about the current and the potential future benefits of AI, but I know many are attending this webinar because they understand that AI poses unique risks. Both lawyers and non-lawyers know that means understanding how to address AI in contracts and how to allocate AI risks between parties. So with that, I would like to turn it over to my colleague, Susan Duarte, and then our special guest today, Neil Peretz.
Thanks, Brian. Hi, I'm Susan Duarte. I'm a partner at Marashlian and Donahue, leading the Marketing, Privacy, Security, and AI practice group. I've spent most of my career advising businesses of all sizes, from fast-growing startups to global Fortune 100 companies, on navigating complex legal and regulatory landscapes in technology, advertising, consumer protection, and data privacy. I am fortunate that I get to oversee a fantastic team of attorneys, and together we work closely with our clients to provide strategic, forward-thinking guidance. Each day, I'm excited to come to work, so I get to help companies turn legal complexity into clarity so they can move faster, they can stay compliant, and protect their reputation while bringing bold ideas to the market. I am pleased to welcome our guest today, Neil Peretz, and I'm going to turn it over to him to let him introduce himself.
I'm Neil Peretz. I have been working for about 20 years, sometimes as a lawyer, sometimes as an entrepreneur, sometimes as both at the same time. I think of relevance to this topic today, I built a company called Contract Wrangler, which started in 2016, long before LLMs were released to the public, that essentially trained computers to read legal contracts, and is still in operation with a bunch of Fortune 500 companies, basically reading their business agreements, finding the key terms, and triggering workflows so people don't do things like have renewals that sneak up on them and that they don't want. And then more recently, I was the general counsel for a company called WooCommerce, which is really probably the largest e-commerce framework business that exists. It powers about 30% of the top 1 million stores online. And among my other activities, I was involved in content licensing to some of the large language models that you see in the market, as well as advising some of my internal clients on how to use AI or not use AI, or when to use it and how to use it. I think we go to the next
slide.
Yeah.
Great. That's fascinating, and it sounds like you have great insights to share with the audience today. Just quickly, I'm speaking tomorrow at the SOCAP Retail Summit. I'll be speaking about AI and its use in customer service. So I'm really looking forward to that. I'm going to pass it over to Brian. He's going to tell you what he's got going on.
Yeah, thanks, Susan. I'm a proud participant of NVTC, which is one of the largest regional tech councils in the US. And Marashley and Donahue will be at the NVTC Impact AI Summit, which is on May 15th, right down the street from our offices here in Tysons. The headline keynote speaker is Vince Cerf, who is recognized as one of the pioneers of the internet. And now he is a chief internet evangelist at Google. So you have to do something special, definitely, to get that title. But I've seen him speak before. He's great. Hope to see you there. Thanks.
And the next time I'm doing conversation with folks is at the International Trademark Association annual meeting. And I will be talking about the intersection of being open source, which could be software, hardware, designs, recipes, etc., but still protecting something in your business so you can actually make money. Challenging topic, but there's a lot of different angles on it. And that's on May 17th down in San Diego, if any of you are traipsing around the area and attending INTA. Thanks.
And also definitely relevant to our discussion today as well. As you can see, we've got a lot of ground to cover. We'll look at different contract clauses. We'll talk about some of the considerations when AI is the subject of an agreement and when AI is not the subject, but needs to be addressed when you're drafting or negotiating the contract. If you could go to the next slide. Yeah, thank you. This is an AI contract I found on Etsy. Well, really, I found it actually on Google. Price point looks good. I can't compete with that, but I have not checked the quality of this. And of course, you can also go on ChatGPT and create your own agreement. In this course, we're going to focus mainly on procured AI and vendor agreements, but vendors, contractors, employees, they're all using AI to do the work of the organization. For example, the marketing vendor, the management consultant may be using AI, even though their engagements are not really AI related or the services they're providing. I could have also added joint venture partner agreements or some others to this list. If you think about employment agreements with hybrid employees or independent contractors, the means used to do the work of the organization and who directs the work is important. Of course, AI is a tool. Its use might be anticipated, maybe it's not anticipated. So, these are the things that need to be addressed in managing the risk. But the key takeaway really is to think about how AI may impact contracts, even when AI is not the primary subject of the agreement, because it's just so pervasive now. Neil, do you want to jump in now?
Sure. Yeah, this was meant to be the kind of game show. Is AI involved or not? And we can flip over to the next slide. What's interesting here is, well, what do you mean by AI? Which goes to your point as well, Brian. If we look at this is from the prior administration, the White House put out a AI Bill of Rights, and if we look at how they defined AI, it is incredibly broad. It basically means all software. Because if you read the definition, it's automated systems, well, that's all software, that impacts you. Oh my goodness. Well, hopefully we mostly make software that impacts people, even if just for pleasure of seeing something change on the screen. So maybe video games are out of the category here. That might not affect your rights or opportunities, although maybe you want to get a lot of Robux or something like that. If we look at rolling forward into statute, if you give me a click there, the way this has been codified in the statute does not make it any less broad. What is AI in the statute? It's software that has a goal. Well, yeah, most software you use, you have a goal for using it. It's software that makes predictions and recommendations. Yep, most software does that. Essentially, this definition here, and this is federal law, would mean an Excel macro is AI, at least under the law. And then if the states haven't done much better, if you give me one more click there, this is the state of Illinois. Not much better. AI is software that has inputs and it generates outputs like, hey, predictions, recommendations, or decisions. So like Fortnite. You play Fortnite, you click a button to shoot the bad guy. Hey, that's an input, and there's an output. The bad guy gets shot on the screen. So yes, Fortnite is AI under this Illinois law. The reason I bring all these things up is to say it buttresses Brian's point that essentially AI, from a legal perspective, is actually everywhere in the eyes of the law. So you have to be very mindful of it. Basically, these AI laws might apply far more broadly than you think. I think this is Susan, yeah.
Oh, sure. So one of the main considerations, and I know we'll talk about it as we go through, is AI has a lot of different laws that flow together, including privacy. We have international law with the EU AI Act and the states with the Colorado AI Act. And then, of course, there's responsible AI principles like accountability, transparency, fairness, and all those things, and then sector-specific governance. I don't know if you have anything to add to this, Brian.
Yeah, I do. Thanks for that. I mean, one of the things, and I know, Susan, you're going to talk a little bit more also about the privacy and data coming up here, but, some of these have standard contract clauses, for upstream, downstream compliance. We're familiar, the EU standard GDPR clauses that can make things quite easier for contract drafters. But when you've got agreements for AI services or data, or for development or deployment, understanding which privacy and AI governance frameworks you need to apply is really important, and particularly when you're contracting. I've been working with clients on the application of the DOJ's new rule on bulk US sensitive personal data. Organizations need to amend employee vendor investment contracts based on that. And if they're engaged in covered transactions under that rule. And in some cases, the DOJ has provided suggested language for those rules. So important to understand and very much related to AI and the data. The Colorado AI Act requires AI developers to provide AI deployers with information that will allow the user organization to perform an impact assessment. So that's important. The seller or the developer of the system needs to provide certain information to the buyer user so that they can make a decision regarding the benefits and the risks of the AI system. So if your organization is deploying AI in Colorado, contracts for AI services or tools need to address that. And similarly with the EU AI Act, it's a complex framework. It requires a conformity assessment for high-risk AI systems, and companies that are already in the market understand how difficult this can be and what some of the barriers there are. But if you're thinking about it, you need to consider that in your contracts now with developers, with partners, with customers, and this can be difficult. But if you have the right AI governance in place, then you can. It's not that difficult. Both the Colorado AI Act, the EU AI Act require AI system risk assessments, as do some of the privacy and data security laws. But this is also a best practice to protect your organization. So when you're addressing AI in the agreement, it's a great opportunity to add language that requires compliance. For AI users, this can mean requiring compliance with specific laws. And it may also include some references to responsible AI principles. So, for example, a developer agrees to clear accountability or specific requirements related to safety or security of the system. So, think about these things at the time you are preparing the contract, understand the context of the governance and the risk requirements and the compliance requirements, and make sure that you address those at that stage. So Susan, I think we're going to talk a little bit more also about training data considerations.
Yeah, thank you, Brian. I think it's probably great if we jump right in. I know Neil's touched on definitional definitions, but I'm going to get sort of more to the heart of the matter and things you need to be thinking about in AI agreements. Of course, one of the main things is actually the data itself. So what is training data? It's the data set that teaches a machine learning system how to do its job. And how are they trained? A lot of generative AI models are trained on vast amounts of data. And what do AI vendors want more than anything else right now? You guessed it, data. They want to improve their models, products, and tools and create a more advanced version of their current product. Even though they want the data, developers and vendors should be making sure that they're selecting appropriate data that is licensed or available for training. The way I like to think about it too is sort of what are you purchasing? So a lot of organizations are purchasing foundational data, which is something that's layered on top of a general purpose AI system. And usually these systems are pre-trained on large data sets. And it's either proprietary to the vendor or it could be an open source model. And so you want to look at the training kind of in two ways. So sort of first, what's coming to you? You can ask the vendor, please be transparent as much as possible. What's in the model? What have you trained it on? Do you have the right licensing in place? You have considered copyright issues. What about, have you done web scraping? Should we be worried about privacy and biometric issues? The other thing I want to make sure I understood is what they've done to mitigate against bias. So to ask to see some documentation about that, and then also to certify the training data. And we'll get into more specifics as we go along, but just would want to know that they're in compliance with the laws for the different pieces of this basic data, the starting point data that we're using. And then from there, also and would look at what the organization wants to train the model on. Do they want to use it? Will this AI system continue learning and evolving during the contract period using the data that your organization puts into the system? And if that's the case, you're going to want to consider building requirements into your contract to be aware of how the data is being used, to notice if it changes, to have the ability to audit the system. Again, we'll get into more of this later. It's okay, we can get to the next slide, input data. Thank you, Maxine. This is one of the most critical aspects, in my opinion, of an AI agreement for the buyer. This information is what is going to be put into the AI system directly. And as I mentioned earlier, what it may use to train the model. So the starting point for me would be to have a discussion with my business teams and ask the organization, what is it you plan to put in it? What data do you care about? Is it any sort of data that has laws attached to it, maybe customer information, sensitive data? I wouldn't recommend it, maybe trade secrets. And then also, how can the vendor that we're working with use the data? Can they use it to train their systems? If you let them train, are you okay with the information being reproduced as outputs for other customers? And I think I'm just staying on this slide to talk briefly about ownership. Generally, the contract should be clear about who owns the data and make it clear that the vendor has no claim to your organization's data. And then specifically with prompts, which is what you're telling the system to do, what you're putting into it, you want to clarify who owns those prompts, as they could have significant value. And you also want to determine whether the prompt should be treated as confidential information and establish rights regarding the reuse of effective prompts, along with other systems within your organization. There's also third-party issues. So you just want to make sure you're checking third-party data for licenses, as I mentioned earlier. And then you want to make sure you're stating what the third party can do with the data. And then if you're more on a developer side or vendor side, a thing to think about is what that customer is putting into your system, making sure you're reserving some protections there, so that if the customer does something nefarious, that you have rights later. I can go to the next slide. So another key topic is sort of this concept, and I touched on it earlier, what service providers can do with the data. So you really do need to be clear what's a permissible use and what's a restriction. So permissions are going to, of course, define how the vendor can use the organization's data. Many times you're going to get license rates thrown in there, considering what you might need to grant to the vendor if the organization agrees that the data can be used for training. And the vendor may ask you to agree that you understand that some of your input data maybe reproduces outputs. So again, that's why it's critical to make sure your business understands that. I think another key consideration is restrictions. So you want to clearly specify whether vendors can use your data to train AI models and under what conditions. Explicitly prohibit the use of sensitive or confidential information for training purposes would be a good best practice. And also consider thorough anonymization. Sort of the last point here is data segregation. So make sure that there's you're reserving those rights so that the vendor's obligated to separate your data from others' customers' information so that you don't have cross-contamination. And you also want to make sure you have strict access controls. And then finally, you really don't need to make sure that it's very clear in the contract what the vendor cannot use. So data classification. And then I think sometimes you'll see that the vendor will ask to clarify that even though you've said it's restricted, if there's something, it's something they can get from someone else, that they're free to use it, even if there's overlap. We can go to the next slide. So a really interesting case that came out recently is the Ross Intelligence case. It's a good cautionary tale regarding using data in a model. In this case, Ross Intelligence received data from a third party, Legal Ease, to help train its model. Thomas Reuter, who owns Westlaw, sued Ross Intelligence for allegedly using Westlaw's proprietary legal database to train Ross's competing AI research system without authorization. What happened was Ross was accused of downloading legal opinions with Westlaw's proprietary headnotes. And then they were using that to develop their competitive offering. Although Ross eventually shut down due to litigation costs, this case established important precedent about the unauthorized use of secondary data for AI training. And so it's important to think about it even as part of your contracts, thinking about including prohibitions against using data for purposes beyond those specifically authorized. That you want to check the underlying training data for licensing rights, as we talked about earlier, and then again, indemnification. Next slide. So you know that AI systems frequently process personal information, and that might trigger privacy laws under different frameworks like the CCPA or the GDPR in Europe, and then also sector specific, so HIPAA or CP&I. Use of this personal data can create legal issues regarding that data subject, making sure in your contract that the vendor is obligated to honor those requests. And then you also want to ensure that there's compliance with all the privacy laws, listing them and referencing any sector specific, for example, health privacy, where personal health information is being processed, and restrict that use. And you also just want to make sure that you consider data minimization principles so that the data is disposed of when it's no longer needed. That's the thing. And then beyond privacy, you want to make sure that you're including robust confidentiality provisions. So creating a detailed definition of what constitutes confidential information in the context of your AI relationship. Establish specific provisions for trade secrets and highly sensitive proprietary data. You also want to document security standards and include very comprehensive and specific timelines regarding breach, what happens during if there's a breach. And finally, just making sure that those confidentiality obligations survive when the contract ends.
Aha, I'm unmuted. I'm going to talk a bit about technical approaches to protecting your data, because these go above and beyond. Even if your contract is lousy or you're forced into some contract of adhesion, there's still technical steps you could take to go protect your data. And frankly, sometimes even if your contract's good, people don't adhere to it. So if you are less of a target because you've taken some technical steps, that's great. Even if they breach your contract, you're a little safer. So the first protection strategy is courtesy of data privacy genius Quentin Tarantino. I'm sure you've read about him on all the academic literature. This is from Reservoir Dogs. And essentially, if you go give things fake names, that is a strategy for reducing at least what people can understand is the subject of your data. And so, that's essentially what happened in Reservoir Dogs. If we go, give me a click there real quick. This is essentially called tokenization. And what you do is you can, if your system can go identify the most sensitive data, like the identity of people, you can actually have software go through and substitute the identity of people with tokens. And you retain the answer key, so you can go take the token and reinsert the real name. But when you send off to the outside service, if you're using a third party, for AI or anything else, you send the tokenized data out. And if it's being processed, then when you get it back, you can, if you will, untokenize it and figure out, who this referred to. And this comes up a lot in the payments industry, where it might be the case that someone actually doesn't have the right security level, like PCI DSS, to be able to hold certain data. And it's not that hard to do. There's even open source software. There's one called ARX, for example, that you can go look up. That's a data anonymization tool. So if your developers are even somewhat facile with your database sources, yeah, they can go ahead and do this. I have seen something that's, I find kind of silly. I've seen anonymization tools in the cloud, which basically means give your data to a third party, and then they'll go tokenize it so the third party won't see it, which you can see how that defeats the purpose. I was going to put in a joke here about how some of your data doesn't like to be named Mr. Pink, but we'll skip that. We can go to the next slide. The other approach, competing with Quentin Tarantino is Stanley Kubrick. This is the I am Spartacus approach, otherwise known as aggregation. If everyone is Spartacus, you don't quite know who they're referring to. There was also a Happy Days episode where everyone was Fonzie for a while. If you give me a click here, I can explain some details about this. Essentially, if I put a bunch of people's data together, I have an advantage in this case where I can still preserve some ability to statistically analyze the data. You can see here, I can get averages, I can get age ranges, and I can remove identifiers. So I have aggregate data and clustering data, but people don't know who the individual data point is underneath. So this is a strategy that's often used in financial services, for example, where we want the statistical insight, but if we have too small of a data set, people can figure out who it is. And that, if you give me the next slide, I'll explain what that is. This is Netflix. Netflix thought, well, we want to get some insights about our users, so we'll anonymize. And so they took 500,000 subscribers' data about movie ratings, and they said, we're going to have a contest. We'll pay you a lot of money if you win and get a better movie recommendation algorithm. And what they found out was, well, there was actually other data in the world. So that even though the direct identifiers were removed, some researchers found that they cross-referenced their Netflix reviews that they had against IMDb reviews, and those were public. And with just a few movie ratings and dates when people gave the rating, they were actually able to figure out who most of the users were, or who a large subset of the users were within the Netflix de-identified data. So you have to think when you're de-identifying something, how do I make sure that someone else with an additional data set can't re-identify it? And the same thing applies in the telecom context. If you give me a click there. This is an example of a call data record. And if some of you are here through Rashley and Donahue, you're probably telecom geeks. Maybe you can even read this. essentially, what the call data record tells you is what are the locations of the towers that were hit by some anonymous user. So you should be able to figure out who was where, who was at the birth control clinic, et cetera. And some researchers again did a study here, and they found out that if they augmented this with other data, and they did a study, this was in a quote small Western country of 1.5. They got the data from 1.5 million mobile phone subscribers, and they found out that if they could get just 4 other data points, that they call them spatiotemporal points, where people were at certain times, for example, or what else people do, they were actually able to identify 95% of the people in the call data record database. So the lesson for this is you need to think about your aggregation levels. You need to aggregate with a big enough grouping that people can't figure out, oh, there was only 1 or 2 data points in this geography. That's why, for example, in credit underwriting, we'll look at a metropolitan statistical area, not a zip code, because we're sure to get a bunch of people within a metropolitan statistical area. And then you've got to figure out what external data do people have. This even comes up when you're doing tracking pixels on, from Meta or something. They've got a lot of external data to go re-identify people. So your own anonymization might not be enough. Give me the next slide. Controlling your data. So this is the case where the model and the model maker, if you're using a third-party model, a third-party system, can be told sometimes, can you train on my data or not? You give it instructions. And one of the things you can do is you could shut off your training. And if you give me a click, yeah, this is an example here of the alternative wording for don't train on my data from ChatGPT. They don't say don't train on me. That would be negative. They'd like this to be very socially deplorable for you to say this, but say don't improve the model for everyone. You don't care about the common good. What that really means to say here is don't train on my data, which sounds much more proprietary and proper. So you can actually click this. But before you do this, it's important to think about whether you want to always shut off training. In some cases, you might actually want the model to go improve. And there might be a situation where your data points help the model improve and you're a user of the model. So you do actually benefit from the model being improved. And it turns out now within the SEO world, we actually have people who are intentionally trying to do things like get websites set up so they will definitely be referenced by various AI systems. Because this is, to some extent, the new form of SEO. Even look at Google's search results. When they show up, they've got this AI snippet at the top. So if you want to be found, you don't want to go shut this off. Maybe part of your strategy is you should be found or the model should be better. So think carefully before you say don't train on my data. It might be a good idea to go let them train on your data. If you give me the next slide there. This is another example of thinking through training. What are they training on? And it's important to understand this if you're using third-party models. Boy, I know it's like a wall of text here. Let me give you the short version of this. These are all different ways to say, you indemnify me. If something bad happens, you'll take care of it. And these all actually mean roughly the same thing. They all mean you'll indemnify me. Now, one of the things a model could train on, and I actually built a company which had models that trained on this, is models might train on how do you say something. They might not care about what's in your contract, for example, but they might care about what are the ways you represent a concept, because the model wants to learn all the different ways that you could say indemnify. It's not really harm to you for the model to learn yet another way to describe indemnification. You don't want them sharing the date of your deal, but the concept of indemnification they can learn on. I'll give you another simpler example of this. If you're ever doing any enterprise selling, you get these requests for proposal, RFPs, and they have hundreds of questions in them. Now, you wouldn't want necessarily a model training on your specific security posture as the way you answer the question, but you might want the model training on, well, what are all the questions that people ask in an RFP? Because the model will get better if it knows the types of things people ask. So you want to think, sort of delve into it. If you actually are able to have a dialogue with the model maker, what specific data are you training on? What use are you making out of it? And it might turn out that even though they're looking at your data, the use is not objectionable in and of itself. You go to the next slide there. persistency matters. This is Dolly's persistence of memory. And even if you're in a situation where someone is not training on your data, you actually still have data privacy risks if they're just sitting on your data. How long are they keeping your prompts? How long are they keeping the data that you uploaded to the system? Even if there's no training that goes on, they are still a target. If you want to get like a lot of data, go break into Claude or Gemini or one of these other systems. Of course, they're well guarded, but the point is they have a lot of data. They're a bank of data. And even if they're not training on you, your data is at risk. Your data is at risk whenever it's in someone else's hands, and these guys are big targets. So what you'd want to do is evaluate how long should the data even be latent on the other site. This is one of my least favorite sections of contracts is all those capital letters. You know, as you're, if you're not a lawyer, you get through the contract, you get this warranty section that's all capital letters and maybe bold as well. And your eyes glaze over. To be honest, the secret is I'm a lawyer and my eyes glaze over too, but I just don't have an excuse to not read it because kind of like the buck stops with me when I'm working on a contract. This is the section where essentially the vendor is trying to tell you nothing might work at all and it's tough luck to you. So someone actually has to read this section. And one of the key things you'll see waived there is they'll say, we want to waive fitness of purpose. And this is actually a term of art, but it's important for everyone to know what this means. Essentially, fitness of purpose is, I want to waive the fact that this actually solves the problem you're buying my software to go solve. And it's important, if you're going to evaluate software, you presumably do want it to solve your problem. Now, you need to describe your problem to the vendor, but if you have any negotiating power, you want to probably remove this. You want to actually negotiate and say, here's the problem set I want to solve. Will you tell me? Will your model help me solve this, at least incrementally move me forward, not necessarily being perfect? And if they say yes, then get rid of any waivers of fitness of purpose. You can also be asking for a warranty on training data. Did you take improper training data in such a manner that's going to go get me in trouble? And then, Brian and Susan already alluded to lots of laws. On the one hand, you can, of course, specify all the laws that you want them to agree that they comply with, but you'll never be able to keep track of all the laws. There's too many of them. So you do want to include a catch-all, like you comply with all applicable laws, and it kind of puts the burden on them if it turns out there's some other law that you forgot to list. And presumably they should know it. And just a word about laws. Sometimes the law applies to a combination of your vendor and you together. And this is actually an ongoing fight as laws are being made about AI. Who's responsible when the AI does something? Is it the person applying the AI or is it the person who builds the underlying technology? And you can guess the people build the underlying technology say, well, you don't know how it's going to be applied. So let the applier go take care of it. So don't assume that, yes, Google's a big company. I'm using Gemini. Surely they're compliant with all laws. It might turn out that it's your use of the AI that actually triggers compliance with another law. Your fundamental model maker might not be able to do all that for you. So another thing you'd want to try to get a warranty on is accuracy. And accuracy actually has two different components. And it's important for you to understand the detail underneath these components when you're talking with someone and when you're evaluating a system, as well as the promises that are made to you. So one of the components we call recall. And here's an example. We have a cowboy, and his job is get all the cows, right? And so he throws a big lasso, and he gets all the cows. Maybe it's a she. She gets all she gets all but 2 cows. Fantastic, right? All the other cows are gotten. Unfortunately, what you can see if you look closely there is they got like the aardvark, the giraffe, the lion, the gorilla. What we call this is great recall. You got almost everything you're supposed to go get. And I'll give you the analogy in real life where this comes up is like lawyers. I'm a lawyer. And if we're going to go litigate, we want to make sure we get every possible applicable case. We're going to leave no stone unturned. We're going to find the needle in the haystack, whatever our euphemistic reasons are to go bill a lot of hours. Be a zealous advocate for our client. You want to have high recall for certain of these tasks. You can't afford to miss anything. So people say, yeah, I'm really accurate. You want to delve into it. Well, tell me about your recall. How do I know you're not missing things? And by the way, the way you test this is you actually have to have humans look at what they didn't capture. You can't just look at the results to see if you got good recall. So there's actually testing of the data streams and sampling that comes in. The other side of accuracy, if you give me a click there, is precision. And this is something where, all right, look, we have the cowboy here. The cowboy missed a lot of the extraneous animals. If the cowboy or cowgirl, she was supposed to go get the cows, she made sure to get, mostly cows. She did, but it turned out in the process of avoiding the other types of animals like the aardvark, the ostrich, the emu, etc., she actually missed a bunch of cows too. This is precision. You don't want too many wrong answers mixed in with your output. This actually matters too. Imagine you're in the advertising industry and you're doing some type of AI and you want to make sure you're driving the right customers to your website. It's very costly on a pay-per-click basis to get the wrong people showing up at your website. So in this world, you'd say, I need precision. Otherwise, you get a lot of the wrong people showing up. The trade-off, though, is you could be missing people who you want to go get. So different use case than the lawyer. So people say accuracy. You got to dig into this based on your use case. What's your recall? What's your precision? How do we go measure that? So these are some examples of actual warranties that people provide in some of the larger foundation models, but there are limits to them. So what Google says is if you use our cloud, one of the areas people worry about being sued, we saw these lawsuits about AI is infringing IP. Well, what do I do if it turns out that a foundation model that I'm using is found to have infringed IP? Does it mean my output is tainted somehow? Do I have a risk? Less so if you get some type of indemnification from your foundation model provider or your application provider. So what Google said was, we promise that if you use our generative AI, we'll indemnify you against claims that the training data that we used infringes a third party. And there is a caveat. We will only, though, indemnify you if you're following responsible AI practices and not using the model to intentionally infringe AI. And this is a debate within the New York Times lawsuit as well. If you give me the next click there. Microsoft, I think Microsoft might have been the first to offer indemnification. They said, look, if you're sued for copyright infringement and you're using our AI, like Copilot or Azure OpenAI or the outputs, we'll defend you and we'll cover adverse judgments or settlements. But you have to use our built-in guardrails and content filters. So again, they're trying to watch out for, are you intentionally using it to go copy someone's IP? If so, we don't want to defend you for that. But at least you offer some protection if you inadvertently are, if you will, the subject of a secondary lawsuit as one who indirectly infringed by virtue of using a model that was trained on illicit data. And then Adobe, not to be left out, they said, we'll indemnify you against any infringement claims based on use of our generative AI. Now, Adobe's really great with generating art, for example. And one of the things they did is they actually made sure to buy the rights to a lot of art. And that way, the generative AI that they use is on licensed data. And so Getty's been out there licensing a lot of the data, saying, you want to use my data for training, pay up here, and then I won't go after you and your users. That's kind of a backstop for Adobe to issue this. If you give me one more click there. There is yet another caveat. Yeah, all these great indemnifications, these are not for free tier users. This is like you're paying us money to go offset this. So, sorry, free lunch went out the window there. Give me another click there. Usage limits. So there could also be limits on what you can use the AI for, and you need to go read this. This can void your warranties, and it can actually result in your provider shutting off your model or the data in the middle of your process. So it's better to go figure this out in advance rather than get caught midstream if you're building this. So one example of a usage limit is it might be that models that are trained on certain types of data can't be used for making certain types of decisions. You can't use it as decision support for credit, employment, housing, insurance. This is under the Fair Credit Reporting Act. Give me another click there. Another example being, you can't use our model to compete with us. Right? Okay, well, what are all the businesses that Google's in, for example? I'm not saying this is from Google, but there could be a lot of businesses that your model provider is in. If you might touch on one of their businesses, well, be careful. It might not be the right model to use. And then give me one more click there. Not surprisingly, they say, don't go train another model on our stuff. And this is an accusation, for example, about DeepSeek. People have suggested that the large Chinese model might be trained on the output of other models. And this is a strategy people use sometimes to say, how do I make a smaller model? Well, I get the bigger model, I get the output, I train a smaller model just on the output of that. So if that's your intent, yeah, be careful. Go read the terms of use of what you're using. Otherwise, you can end up with a real headache. You use the output, you built a bunch of work yourself, and then it turns out, oh, you're going to be in trouble if you use it. So another thing that people will promise you, oh, yes, we have humans in the loop. That's really not enough. That's a pretty low standard, as much as I think humans are better than other types of animals in certain activities with our opposable thumbs or ability to do calculus. You really have to delve into this. What is the sampling rate they're using? The mere fact that I have a human loop somewhere, it could be Homer Simpson sleeping at the keyboard or dashboard of the nuclear reactor. How much of the data is being checked? You really need to go delve into this. What is the sampling rate here? Imagine here if I sampled 1 out of every 5 or 6, I wouldn't miss this. I'd miss a lot of the situations in which, yeah, they got it wrong. It wasn't a human. It was a bread box or a light bulb in the result, or maybe it was a car or a ghost. So what's the sampling rate of the data? You want to delve into that next. Who are the experts? They say they've got experts. Great. Who are they? Is it Ken Jennings or little Bobby? Right? You really need people who are trained in a certain subject matter to be checking the result. And how are the humans incentivized? How are they trained, et cetera? Mechanical Turk will provide you humans. They breathe, they're human, but they might not know your subject matter. The next slide. Another thing to ask with human QC is, are the humans checking each other? And this is one of my big learnings from AI is if the humans can't agree, the AI is not going to do a very good job. AI might do a worse job. So this is an example here. The question I would pose to these people to get these answers is, you have a contract. It starts January 1st. It lasts for 1 year. When does it end? Okay, the husband says December 31st. The wife says January 1st. Yeah, they can both be right under different legal regimes. Essentially, if you're running QC, you need to actually, in some cases, run multiple humans together at the same time with the same problem and see, do my humans agree? Because if the humans don't agree, you can't train the AI with the result. Instead, what you get, where the humans kind of arbitrarily disagree for other reasons, is you essentially get, in the next slide, you get the AI as a conspiracy theorist, basically. Because the AI is essentially hunting for meaning. It's hunting for an algorithm. So, I gave you this previous example. One person said December 31st, the contract ends. The other one said January 1st. The humans didn't agree. The human trainers, the human QCers didn't agree. What the AI is trying to do is find a theory here. They're trying to find a theory why all the results are correct. So the AI might say, well, the guy who said December 31st gave me the answer Tuesday at midnight when the weather was 73 degrees. And the woman who said January 1st, she gave me a response on a Wednesday at 12 p.m. and it was snowing outside. And the AI says, aha, I must find a pattern. Well, when it's snowing, it must be, January 1st. And when it's sunny outside, it must be December 31st. The AI is trying to find a rule. They're trying to find a connection, even if there isn't one. So essentially, if your humans can't agree, your AI is going to make up theories, and they're going to be worse than being random. And you don't know if your humans can agree unless you run multiple humans side by side and you test what we call inter-annotator agreement. So these are all the topics to think about when someone says, yeah, I have a human in the loop. Okay, great. What is that human doing? How do you check those people? The next slide. And this is Susan, Brian.
Okay, yeah, very good. Great information. And we only have 10 minutes left. So I'm going to try to just pick out some high points here. We talked a lot already about data, licensing, training data. Yesterday, I had a conversation with Mark Lindsay from ECG. He has attended some of these courses. I'm not sure, Mark, if you're on right now, But he was talking about weights and parameters for trained and tuned models as a new data type. We were talking in the security context, but carries over to licensing and IP ownership as well. After the model is developed by a third party and is trained on your organization's data, we need to consider, some of the same familiar software licenses. Public domain, is it open source, copy left, proprietary? If your organization is contracting with AI developers, it's important to include requirements that ensure clear IP ownership of the code. This has become more critical as developers are starting to use these code generators, of course, and that is going to continue, that adoption of the generative AI code tools. You talked a lot about permitted uses and restrictions for the AI systems, so I won't go back through that. There was other really great discussion about that, understanding what that use is. Also, access to the system. Do you have access to the system after deployment? Does a buyer have the license to make system level changes to post processing, to the model tuning? Maybe it's necessary. Maybe there's security, or you need to adjust the guardrails. That's important. I think IP ownership was talked about. I won't go back into that. That's obviously in flux, but needs to be addressed. So I won't go back into that. But I think Susan mentioned trade secrets as well. Obviously, that's critical if you want to maintain trade secret protections on information or source code, and you need to take additional measures. You need to look very closely at that in terms of contracts and how you're dealing with trade secrets. Susan, you wanted to talk some about liability and indemnification?
Yeah, no, thanks, Brian. I know we're really short on time, so I'm also going to just pick out some highlights. Obviously, this is very important in these types of contracts. Neil did a great job of showing us different IP infringement issues or things you might be seeing. But you definitely want to make sure that if you're a customer, you're looking for a broader indemnification. It seems like your vendor may try to narrow it. But you do want to make sure you're covering regulatory compliance issues, of course, data privacy violations and output related harms. And with regard to liability, you do want to try to get certain things carved out, and you're going to want to make sure that there's liability caps for you. And if they're trying to have liability caps, that maybe you're trying to carve out exceptions for data breaches or confidentiality violations. And then you may also consider even having a phased liability approach as the relationship starts to mature. And then also you just want to make sure, as Brian's talked about, making sure you have responsible frameworks and that the liability accounts for that.
Yeah, so support for we're near the end here. Support for procured AI systems. At its core, AI, it's software, it's data. Some of those same support criteria are important. Obviously, can you reach the help desk? What occurs when escalation is needed, or if there's a security incident? Deployment integration support is important, similar to software, but there are, of course, specific concerns here. So make sure that AI is not simply treated as another SaaS solution when you're thinking about support. Of course, AI, frequently a creature of hybrid cloud environments. SLAs can come into play. Some of those same metrics, uptime, obviously apply with AI. There was some talk before about metrics and accuracy and things like that, precision. Maybe some of those metrics come into play. Of course, that means agreeing on representative metrics, which can be difficult. Another example is monitoring and measuring for post-deployment bias. You can come up with metrics and identify and agree to in that for that kind of situation. But expect to see this more, because we know that organizations are adopting AI in mission critical operations more and more. So these kinds of current concerns, business continuity management and disaster recovery are important. And post-deployment monitoring as well, we know is critical for AI systems. So if that's required, monitoring for system failure or bias or other things, then who does that fall on? Is service provider doing that? If the user is responsible, what monitoring capabilities are built in? Do additional monitoring systems need to be put in place for controls? If the system has continuous learning, of course, then these issues become more important to address. And of course, similar to software, AI needs updates and upgrades and updates. So that sometimes means retraining, tuning the model, deploying a new model. Make clear who is responsible for those different tasks. And I always like to mention documentation and training. Make sure that you include it in there that these AI systems providers need to give all of that information, all that documentation and training support you need to have robust training for your personnel. You can go to the next slide.
Yeah, so the party's over, it's time to go home. You're at the termination phase, either for breach or just because the contract is over. Sort of rates to think about in advance, making sure you have clear requirements for handling customer data. Also, model access termination, the protocols for ending your access to the systems, training data rights that should address whether that AI provider you're purchasing from can continue to use your data. You may also want to consider asking for transition assistance so that they help you move from one system to another. And then, as we talked about, IP ownership. And then sort of in the breach contract, you do want to maybe start to think about having provisions that talk about ethics violations. So you have cause in case of those types of issues, especially for reputational harm. And then also provisions that address what happens if new regulations come out that affect the legality of what you're doing. And then for survival purposes, how the proprietary model developed can be used with future clients of that vendor, and then whether or not the vendor can use the algorithmic knowledge, it's hard to say, with that they've gained from your interactions for their model, and then obviously regulatory compliance. And survival, you also probably want to consider confidentiality and IP rights and what happens with data usage and retention or mandatory deletion.
Yeah, so we have an interactive workshop on contracts coming up in a couple of weeks, and Neil will of course join as well on that. So hope you can join us. We've gone a little bit long. You can go to the next slide if you like, but I can stay on. Hopefully Neil and
Sure.
Susan also can stay on for a bit. I think that if you have questions, I believe, Maxine, you can correct me if I'm wrong, you need to go to the chat to provide those to us. Is that right? Yes, I see. So if you have questions, feel free to drop them in the chat.
Or drop us a note later.
Or drop us a note later, exactly.
And so related to the later part, we should also put up the other slide that has our contact details, right?
Yes.
While we're taking questions. That way people have to hop, they can
Absolutely.
see email addresses and LinkedIn's
Absolutely.
and such for people.
Yeah. And we ran a little bit long, but I hope you agree there was some great information in there. And thank you, Neil. I mean, super interesting insight on this, and a little different from just the the attorney's perspective. Although you're an attorney, you
Yeah.
give us a twist and a little different perspective, which I really liked.
Oh, I got a note from someone that says chat is disabled on the webinar. So that
Oh, well,
probably
that
impacts the amount of questions that will come in.
that would be a problem. Yeah. Yeah. So Maxine, I don't know if we can make that live.
Well, we can have Claude or someone generate some questions,
Mhm.
All right. So I'm told it should be enabled. I'm told it should be enabled now. Maybe that's another good use for generative AI. Coming up with questions from the crowd. John Doe 1. What do you say?
Well, we
I have a
are at end of
question.
time, and we
Oh.
kept the chat blocked for anyone who actually did try a little
Yeah,
earlier.
we
So
frustrated.
apologies for that.
We frustrated people's attentions there.
Yeah, yeah.
See, we talked all about the AI problems. Humans have fallibility too.
Yes, we'll definitely make sure that the webinar is available. We'll send it out afterwards. Neil, just sort of, what is your biggest takeaway as our guest star today? What should people be
Good way
remembering?
to close.
Yeah, it's such a fast-moving landscape. So if you're doing these contracts, there's really a lot of laws and considerations you have to keep track of, and you need to pay attention to different clauses in your agreements than you typically would.
Yes,
Yeah, excellent point.
more work for
And
lawyers.
just to add to that, and we highlighted it throughout, you need to look at these AI agreements where you're purchasing AI services, tools, or whatever it might be, as well as these other agreements and how AI impacts really the services that you're contracting for, the employees, et cetera, because it's changing everything. So let's see. I see actually a lot of thanks. So thank to everyone. And some people said they'll follow up, which is great. Thank you very much. I'm going to be searching for more info on laws in Texas. Would you trust platforms for data reports?
I'm not sure what's meant by data reports.
Right.
If the person whose name begins with V could clarify, I'd be happy to take a crack, or you guys can.
Are you talking about like data cards or information about transparency information about data? Or are you talking about?
Oh, is it your data that's being analyzed by the system, or is it third-party data that the system is summarizing?
Or the training data, what do
Right.
they have in the system?
Right. Yeah.
So I don't have a more clarification on that, Victoria. If you, oh, here we go. Excel customer information, services, active potential sales.
Yeah. This is something that I would definitely consider some type of anonymization or tokenization scheme, rather than revealing some of your client info. And then you've got to go get to the level of tokenization that you don't give out the specific address, maybe, because people can still be cross-identifiable with that. But yeah, you definitely might want to group the customers into certain categories, for example, by prospect or some type of psychographic personality. So that would require some substantial data munging. But you could do it in a semi-anonymized or tokenized way.
Yeah, a lot of these trust platforms too are becoming very, very good at data discovery, at going through the data and using AI, in fact, to analyze data and understand where confidential data is, where, so, and that's a lot of times now rolled into some of these different trust platforms. Let me see. Thank you. A lot of thank yous. So that's great. And thank you all for joining us.
Thank you.
So we're at 1:35, so ready to sign off. And again, hope you can join us in 2 weeks for the workshop. Hope you had a chance to scan our contact info and reach out to Neil, reach out to Susan, reach out to me if you have any questions. I'm glad to answer them. So thank you very much.